Good afternoon to everyone. A very warm welcome to all our esteemed speakers. So in this panel discussion today, we will analyze the provisions of the DPDP bill, the contentious aspects it has watered down, and how it addresses the concerns of the consumers. So let me begin with, Mr. Bajpai. You can start with making us understand the contours of the bill and how different it is from the previous versions of the bill. And then, the panelists can answer, give their views, the first impression of the bill. Yeah.
Thank you, Monica, and good afternoon, everyone. Before I answer your question, I just want to step back and talk about the context in which this bill is being enacted. India today is the largest connected democracy. We have almost 750 million internet users, and this number will get to almost 900 million by 2025, and to 1.2 billion very shortly in the next 3-4 years. Given that is the number that we are talking about, data becomes center stage. And data today, and also in India, I think the per capita consumption of data is pretty high, and in the years to come, it's going to only become higher. Given that context, I think the data protection, the new digital data protection bill couldn't have come at a better time, although we've been asking for a regulation for some time. But I think the new bill I'll talk about the new bill in two buckets. So one is the form and manner, and the other one is the content and substance. So when I look at the form of the bill, I think it's both comprehensive and comprehensible. At times, when things are quite comprehensive, they are not comprehensible. But when you read this bill, it's written in a very simple language. It has 30 clauses as against the predecessor bill, which had 90 clauses. And it's written in a fairly friendly, non-legal language. So that's one point that I wanted to make. The other one is the fact that it is quite streamlined. And I will tell you why when I come to the content part of it. And something which is quite significant, while for some people might call it symbolic, but I think it's substantive, where for the first time in the Indian legislative history, his has got replaced by her. So if you look at the clauses, everywhere the reference is to her, which I think in today's day and age, when we talk so much about equity, diversity, and inclusion, is a watershed moment. So that's, if you like, is more on the form and the manner. But if I come to the content, like I said, it's a simple bill. It's pretty simple, it's pretty streamlined, because its application is only to online data and offline data that gets digitized. So by this by itself makes it quite streamlined. Yeah. The bill is based on, a lot of it has been taken from GDPR, as many of you would know about GDPR. But the bedrock, there are 7 or 8 principles which are at the bedrock of the bill. They all talk about, lawful manner of collection of information, personal data. It talks about purpose limitation. You should be using personal data for the purpose for which you are processing it. It talks about storage limitation. No data can be stored, no personal data can be stored for perpetuity. It talks about accountability, it talks about accuracy and updating the data. So these are, if you like, they are the bedrock, they are the basic guiding principles along which all the 30 provisions are substantiated. There are quite a few other features of the bill. There is a reference to ADR, and that is increasingly being the case in all evolving regulation, and I personally welcome it. So if there is something where the Data Protection Board feels can be mediated between the parties, it can be referred to mediation. So there is this ADR mechanism available. There is something which is called the voluntary undertaking, where on matters of compliance, if you feel that there is something which you need to bring to the notice of the Data Protection Board, it's like compounding in other regulations. So if you end up inadvertently doing something which transgresses the bill, there is an opportunity for the data fiduciaries and data processors to actually, ask for a request for submitting a voluntary undertaking. There are many other novel features in this bill which I think will go a long way. In the predecessor bill, there was almost a tiered taxonomy of personal data. There was something called personal data, there was sensitive personal data, and there was critical personal data. And when the bill came, the last bill came, we didn't even know what critical personal data will entail because government was going to prescribe what it will entail. Also, there were restrictions on cross-border transfer of critical personal data. But this one is again, I come back to the point on simplification. It doesn't, it doesn't have sub-categorization. It just has personal data and that's it. On cross-border transfer of personal data, which has been a very contentious matter, I think again, the bill talks about factors which the government will take into account and countries that they will notify where personal data can be transferred. And I'm sure when government does that, it will take into account aspects like reciprocity, equity, and reasonableness, and the kind of infrastructure that exists in the counterparty country, where they would want to obviously ensure themselves that whatever data gets transferred, personal data gets transferred, is safe and secure and is not likely to be breached. Having talked about the positive aspects, and there are quite a few more, but in the interest of time, I will not really dwell on everything. But I do feel that it's also a case of missed opportunity, because this is on a subject which actually requires behavior change. As a country, as people, we are not quite tuned to not sharing. And we share data at the drop of the hat. So I personally feel, and I agree fully with the JPC report which had come out some time back, which said that there should be a 24-month transitory period, while the bill might become an act and may come into effect. But what is required is to develop awareness. And I would have loved if the Data Protection Board of India had one of its functions to really build awareness around privacy, around data protection, around personal data, because people don't understand, and we have to be mindful of the fact that much of India lives in villages, and the law applies to every citizen. So we should ensure that there is huge amount of awareness that is built, because behavior change and creating a privacy culture is never easy. Cultures are created when behaviors change. Behaviors take time to change. So I think somewhere I do, when I read this, and when I read the functions of the Data Privacy Board, and it starts with ensuring compliance and imposing penalties, that's all fine. But you need to educate people. Unless you educate people on a subject like this, you will end up having huge amount of non-compliances. And I don't think that's anyone's objective here. So I think one of the missed opportunities is on awareness, and I hope if industry can rally around this, and I think JPC had recognized this, and that is why they said that there should be a 24-month transitory period. If there's something that the government can even think of it now, it will be useful. So that, if you like, would be my initial comments.
Okay. Mr. Chakraborty, what were your initial, first impressions, and what are the key issues with the bill? Yeah.
Thank you, Monica. In a session post-lunch, you have to factor in a few bits. So one is obviously the partial brain freeze post an insulin slump, and also when you've had such a lucid summary of the bill being given by the first speaker, there's hardly much to add to it. But I think what I'll do is I'll probably look at a couple of categories and probably go by that. And my understanding of data privacy is unfortunately or fortunately at some point of time more colored by my understanding of the GDPR, because I kind of treat that as a gold standard when it comes to data privacy. And it has nothing to do with nationalism, it has nothing to do with anything else. I just believe the nuances in the GDPR a little more, and I kind of look at that as the gold standard and tend to compare everything else with that. So when I look at the present DPDP bill, and I would want to kind of probably factor in 3 categories that I would want to look at it. First is the subjects of the bill itself, which basically concentrates more on the data and the data principles. Second would probably be around consent. And thirdly, I would want to kind of look at what is it that it actually speaks about the rights of data principles or data, or the people who actually have data. So if you look at these 3 categories, these kind of give you some sort of a perspective as to where the bill heads and where is it as compared to the rest of them. So on the subject of the bill itself, data per se now relates to data which relates to persons. It also relates to a bunch of other legal and juristic entities. Now, when we talk about the GDPR, we are talking about very specific data of individuals and individuals alone, where there has been an exclusion of all legal entities and juristic entities. So there is a clear difference between personal data and data which belongs to juristic entities such as corporations, HUFs, associations, all of that. Now, that is not something which comes across in this bill. Whether that by itself is an attempt to make it more comprehensive, or whether that is by itself another attempt to ensure that you take on a legislation which kind of takes on additional categories which it would have not done otherwise, I do not know. But I don't think what the bill does is elucidate on any of that. It does not speak about corporate data. It does not speak about other things. If you look at the bill also looks at, it tends to take away the sensitive personal data rules that we've had since 2011. I'm assuming a repercussion of this bill coming through is that data goes away, that rule goes away. If that does, there were certain nuances of data there where we spoke about sensitive data, where we spoke about financial information, biometrics, and a bunch of other things which was treated at a category which was slightly different from the rest of the personal data. Again, the bill at some point of time in some illustration speaks about biometric information, but does not seem to categorize sensitive personal data as one and personal data as another. So it tends to kind of take away from that factor. Additionally, once you look at it, you also see that the data principles involved are, since it becomes corporations and juristic entities, we have this interface, possible interface with trade secrets, confidential information, and there are references to that in the bill. I am not aware of a trade secret legislation in the country. I'm not aware of confidential information otherwise coming in other than under contracts. So I'm not too sure as to whether, again, this is an attempt to take it a little further and add on further bits to the bill and take it as data privacy, including corporate secrets, including other information with regard to entities. But at some point in time, the bill at the present moment does not seem to address that. If I move on to the second category that I wanted to speak about, which was basically consent, it speaks on the same lines as the GDPR, says that consent has to be free, specific, informed, and unambiguous. So that's exactly what the GDPR says. However, what it also does, it builds in a concept of deemed consent. Once it says deemed consent, is it any longer specific or is it any longer non-ambiguous? I'm not too sure as to whether that also comes through. But at some point of time, I love the concept, and let me be specific here. I personally believe a deemed consent concept could be extremely useful in the future as well, because considering the country that we are, considering the kind of data that we've spread out with regard to our personal data, which is already there in the system, which is flowing through various data fiduciaries at the present moment, I believe deemed consent can surely be a concept that can be used. But can it be used in the same way that it is used at the present moment? I don't think so. I think nuances need to be worked out. And thirdly, with regard to the data itself, if you actually look at the rights which are put in, the rights clearly speak about right to be informed, the right of erasure, the right of rectification, all of that. And that, again, borrows from the GDPR primarily. But what the GDPR does and what this bill probably doesn't is the GDPR speaks of what data fiduciaries are supposed to do, the principles by which they are supposed to look at the data. This bill speaks about a few rights, does not speak about, there are no guidelines for the data fiduciaries. They do not know what is it that they are supposed to do, what is it that they are likely to do. So when we look at the GDPR as an example, you have data processing. Data processing by itself has an element of security, an element of transparency, an element of ensuring that there is no automatic profiling, and a bunch of other things which are all built into the processing. When you look at the bill now, the bill does not speak about that. The bill, again, speaks about certain rights. We all understand, I'm not trying to be critical of the bill, but at some point of time, I believe since we are discussing it, we should understand the nuances of the yardstick by which it's being discussed, and also understand the nuances which the bill has in itself. The bill clearly does not speak of the guidelines that a data fiduciary should have, the way it should function. What it does is it does lay down a few concepts. It says these are the rights that you have, and those are the rights which are there. So I believe if we probably look at some of these concepts, if we are able to kind of build it in a little better, provide a little more detail to these provisions, I think the bill could probably turn out to be way better than the avatar that we are seeing it in now. So Monica, that would be my initial views on the bill.
Great. Coming to Mr. Shukla, sir.
Thank you. So I would think, taking from some of what you referred to, the rulemaking process as delegated legislation should hopefully cover much of the detail and the required clarity in terms of just how the various parties are supposed to interact in the process of exchanging data and keeping data in the manner in which the law wants it dealt with. So, and then to Dave's point, again, hopefully there will be enough of a gestation period for people to be able to assimilate and actually be able to apply all of the detail that the rules will bring. I think one interesting aspect of this law and possibly the digital law that is in the works, I think an interesting move from very, very layered and intensive statute is the move to brief, somewhat, principles-based approaches to the framework of statute with much of the detail coming into the regulation. And one of the things that we've always been very mindful of as a country in the legislative framework is that the more detail you have, the more likely it is that people will fall foul of that detail. More so now because of the rapidity with which situations change. And therefore, the perspective needs to change to the less iron-bound it is, the better it will possibly be for all of us as we implement or as we seek to protect ourselves, depending on which side of the pale we are. But also, I think, in the context of prescriptive regulation lies the risk that the more you seek to not prescribe, the more concern there will be that people might arbitrage positions or interpret positions. But an interesting riposte to that I heard recently also is that even where you have detailed prescriptive regulation, people will have to interpret it some way or the other, right? So it'll be interesting to see how this plays out in terms of the transparent approach to perhaps setting industry standards. There is not one industry that is going to be impacted by this, so it obviously in some ways will diverge. But hopefully from the principle of what it means in terms of respecting an individual's data and within the realm of what is digital data, we'll have to see where it goes. One other quick point I'll make is that there are exceptions in this draft bill also in terms of what it does not cover, which implies that much of what you referred to, which is already out there, right, as we sit here, it will still need to be treated in a certain manner. There are sectoral regulations that are already there in varying degrees across insurance, banking, the medical field in terms of what confidentiality means, how you're supposed to treat information, what you're supposed to do with it. So one thing that I think we'll all look out for also is how will all of that converge, and what will we do to make sure there's no conflict in terms of how things are supposed to be treated. Madhav?
Madhav, what are the positive changes of the bill?
Positive? Yeah. No, I think, look, sorry.
And your take on the bill?
Sure. See, I think my reactions after having read the bill, I think it's a genuine attempt to simplify, very clearly. Genuine attempt to simplify. We've been at this for the last, we've spent about 10 years in different avatars of the bill. We had, started off with, of course, very initially it was, Justice Sri Krishna who was requested to kind of put together a panel and look at it in terms of data privacy. Then you had the Supreme Court judgment, then Puttaswamy Supreme Court judgment, and then subsequently the Justice Sri Krishna panel report. We had 3 variants of this bill, 2019, 21 withdrawn, and of course now this avatar. So I think after having spent, and when I was actually doing a little bit of research on the internet for this topic, ton of literature which says you could have done this, you could have done that, you could have done this, right? I think couple of things which are required, what they have tried to do in this is put together a framework. You've got the rights and obligations of the data principal, the data fiduciary, the obligations that they have, consent. So you've got what is required. Now, yes, you can embellish it further with language, you can get into detailing, ask ourselves whether we want really to replicate the whole complicated GDPR today, because we are still in a very evolutionary phase as far as data privacy is concerned, and therefore, would you accept a simplified version? Would you accept, of course, with a robust delegated legislation which will clarify all of the asks that we would have? We should go with it. That's how I would say my first blush when I saw when I read through the legislation, the bill, I believed that good, it has got stuff that we want. We will learn. Of course, there will be a lot of jurisprudence that will get developed, so on and so forth, but we have given it a good shot, and I think we should progress with it. That's my first reaction. Second, what are the differentiators? I think there has been a marked change from the previous ones, which Mr. Bajpai very clearly articulated. But some of the things like, I think the whole data localization piece, right? That was a big one, which went into a lot of discussions, etc., which they have said, we will put it out there. We will tell you the countries where there will be that you can transfer data. So I think, and of course, the finer details will hopefully emerge in the rules as to the government coming out with such notifications and so on and so forth. But I think that whole data localization piece, which was actually stopping us from actually embracing an act, I think that should, in my view, let it be decided by the government. You allow this clause to flourish. 1 point. Second, I think the whole consent part, there is a new variant of consent which was not there earlier in the earlier bills, the deemed consent. And deemed consent is important. You need, and it actually, when you take time to read the bill, you will realize they have given simple illustrations with which you can understand the whole, where are the, you want to book a table in a restaurant, it is deemed you've consented to. I think the whole spirit is to simplify and get going. That's the direction, and in my view, right direction. Third, the whole point around the subcategorization. The earlier avatars had, the whole data, sensitive data, I think critical data, some of the variants, some of the earlier avatars of the bill. Today you've got data. Personal data is personal data. I mean, they've not subcategorized, and therefore that's a change. And I think again, in pursuit of simplification, I think the whole notices part. Notices now they've said you have to itemize it and give notice. You have to essentially ensure that you get into a particular detail. You give the description of use and all of that, which is having a shade of 2021 bill. So I think these are some of the personal versus non-personal data. Yes, they could have possibly clarified but for reasons, I think even the JPC recommended, if I'm not wrong, JPC also recommended make it personal digital data. They've gone that way. Hopefully, there may be another bill which will talk about non-personal data. We don't know. Overall, in my view, I think, again, at the cost of sounding repetitive, simple, lucid, I think sets the framework, gives the principles, but the devil is in details in going into the rules.
Mr. Bajpai, in your analysis of the bill, you spoke of the Data Protection Board, should act as a facilitator, and in addition to being a regulator. So tell us about them, the role.
So look, every regulator should also be a facilitator. So it's not that I'm suggesting that they should act as a facilitator as well. I think the job of the regulator is also to promote the sector. And to that extent, the regulator also has to be a facilitator first and then regulator later. In this case, it's all the more relevant for the reasons that I already mentioned. That if people are not aware of what they are supposed to do, what is personal data? How do you respect your own personal data and more importantly of someone else's? So the 24-month that JPC was talking about, and I completely agree, should be the transition period where there should be huge amount of awareness built around personal data, about this law, what are the rights. It's good to see all the rights and obligations in the bill, but actually those have to be demonstrated, people have to be made aware of, and that's where I think the role of the Data Protection Board as the facilitator comes in, where they spent a lot of time, effort, energy, money, and industry should join hands with the government to see that there's huge amount of awareness that is built, and that's where the role of the facilitator comes in. So I talked about facilitator in that context, basically.
Okay. Mr. Shukla, what are the factors that will have a bearing with regard to India's Data Protection Board in the bill? What is the significance of independence in rule-making powers?
So if it's to serve as the regulator for the purposes of this statute, then I think independence has two facets to it. One is how balanced is it going to be in terms of the various. Obviously, every law will have carve-outs and exceptions, right? Because there is no absolute. And you will see even in this law that there are exceptions to how you can treat information with respect to what needs to go overseas, right? The law itself provides for information that is obtained from offshore, right? Not just domestically. Then there is the construct where a number of factors, because of a number of factors, data will be exempted from the purview of how it's otherwise supposed to be treated by a data fiduciary, right? And then, of course, for various legitimate reasons, the government will have the power to deal with information in different ways because of security reasons, for a number of actions that the state needs to take to protect the people and to protect the sovereignty of India, right? So when you look at all of this in its entire conspectus, the board will have a very important role to play in terms of how balanced and how well defined and articulated the rules are. And in the real world, we all worry about how different influences can come to have a role to play, right? Lobbying is something which is considered a factor that does have a role to play in many parts of the world in terms of how various interest groups could seek to have rules framed in a manner which perhaps suits their interests more than the interests of other people. So from an independence perspective, I think the board has a very vital role to play in terms of how it takes into account all of this, how it's able to distill all of this and come to a position where anything that is framed actually takes forward the intent of this law in the best manner. Right? So that's why independence from that perspective, taking into account all of these pushes and pulls and dynamics, is very important.
The bill says that, the board is controlled mostly, the government, chooses the board members, and it will be controlled by the government. So how, will they be so independent?
Yes, because most law which puts into place a regulatory body or a supervisory body in order to implement and carry forward the law is in fact appointed by the government. Right? What we don't know for sure is whether this board will also have provision for independent participation or participation from industry or participation from any other part which is not the executive. We don't know that yet. But also in legislation that can be provided for, right? I don't think in itself the fact that the government has the power with respect to the office bearers for a board necessarily makes it dependent or necessarily makes it subject to becoming anything but independent. That plays out then in the context of what comes out as rules, and that also plays out then in the judicial framework, right? In terms of what is challengeable or what is not challengeable, because it may not have been implemented or crafted or drafted in a manner which actually suits the intent, right? So that is to be seen. One can't.
They had called it authority.
Yeah.
Now it is a board. So optically, they've tried to also not color code it as, it's the authority. So that slight subtle changes, may give a lot of impact optically.
That's right. And also, if you look at it, just one more point, if you look at the framework for the board in the draft bill, it's very, very high level. So much of the detail will actually evolve through, I believe, there will be public consultation. There will be deliberations with respect to what the rules will provide for. And it will go before parliamentary committee. It will go for debate. And therefore, in its final form, I don't see why we will not have all of the opportunity as a country to see that this is actually going to be truly independent.
Okay, yeah.
I just wanted to add to say that they do use the word autonomous. So there is use of the word autonomous in the bill, that the Data Protection Board of India will be an autonomous body. There is also reference, if I remember correctly, that most of the working of the board would be digital. So the assumption would be there would be people who are savvy, they understand this, they are from different walks of life. Obviously, the rules will prescribe the terms and conditions. And so there is every indication that it will be autonomous and it will be quite independent.
Okay. Mr. Puluru, coming to the industry-specific questions, how do you view the data protection bill giving the government, when the bill becomes a law, how will the consumer have the right to take legal, position against the OEM if they feel their rights are not protected? what will be the role of the manufacturer of the contract and the customer and the OEM?
Yeah, in what you ask about customer, the bill would call him or her data principal, right? Manufacturer, distributor, dealer, whatever variants you call it, will be the data fiduciary as applicable, right? Now, the regime is well crafted in the bill of grievance redressal mechanism. I think 1314 section talks about or lays out the whole procedure. If a data principal, that could be you or me, have a concern, walk up to the data fiduciary, lodge your grievance. Data fiduciary should bona fide act. If you believe you've not been given enough hearing, whatever, it's not come in the way you would want it, you have an escalation mechanism to the board. And now board, again, if you can't recollect immediately the section number, but you go through the powers of the board, very well laid out, akin to a civil court. Orders passed by the board are equivalent to a decree of the civil court. So there is a whole mechanism through which the board is supposed to conduct an inquiry and pass an order, and the effect of that order. You're still not happy, you can take that in appeal to the High Court, right? So therefore, the whole process is well laid out in terms of how a grievance can be addressed. There is, interestingly, I mean, again, anybody in the audience or of the panel can correct me, I have not come across legislation, a bill, and possibly becomes a legislation where there is a significant monetary penalty of the magnitude that is laid out here. 250 crores goes up to 500 crores for non-compliance. I think that's a huge check, if you like, from a data principle point of view. Is there enough rigor for protection of personal data? At least it calls out, when you go through the bill, you will realize that there are enough enablers to kind of give that comfort to a data principal that should he or she not be given due hearing or if there has been a breach with personal data, there is a recourse, and that recourse has got significant penalty implications. So I think the bill very well lays that out.
So there's law in place, the contract has everything in place. So Mr. Chakraborty, I'll come to you, but Mr. Shukla, I wanted to ask you about the alignment of the bills, with the current law, DPDP law. How will, streamline the existing obligations in that?
No, thank you. So I think the streamlining will be an interesting canvas that will have to play out, because I mentioned the fact that there is sectoral regulation already in place. There are expectations. The sensitive information rules under the Information Technology Act themselves will have to go away or be morphed into something else. But in terms of, say, banking regulation, KYC requirements that are not just banking but capital markets requirements as well, anything that you take from customers in a variety of sectors, with respect to what you need to do to fulfill either regulation or government obligations. A whole lot of this will have to be looked at in terms of how do you streamline it all, so that one is that if there are specific carve-outs that you need for particular purposes, those will continue to be what they are, and I believe the draft law provides for that leeway. But where, for example, some of the rules under this law then specifically prescribe the manner in which you're supposed to deal with personal data, as opposed to, say, what perhaps the PMLA Act or the Income Tax Act may require, or banking regulation may require, in terms of the period of time and what you need to retain, what is perpetual, what is not perpetual. All of that will have to definitely be ironed out in terms of making sure there's no inconsistency. Because And then if it's digitized too, right? And it probably, most of it will be in any case. So in terms of what's digitized, what's not digitized, and then how do you sectorally make sure that everything falls into place in the same way, will be part of the whole exercise as these rules come out and we have more clarity in terms of how this is supposed to operate.
So, Mr. Chakraborty, could you tell us about how the bill is clashing with the IP rights concerns? Media company being a media company.
So, okay, let me break this down into a couple of things. One is, as a media company, the bill honestly does not make too much of a difference. It does make a difference in a certain aspect, and in certain aspects it doesn't. So, primarily as an example, we have a digital OTT platform, and I believe everybody in this room has used an OTT platform at some point of time or the other. And the information that is there with the platform is probably divided into two parts. One is your financial information, where you've paid for the service, which, as in Mr. Shukla will probably know much better about the PCI DSS regulations and a bunch of other things which kind of apply, and that's how the payment gateways. So it's all protected there. With regard to the other information, it's about profiling a user and saying that, okay, if you like a romantic movie, to come back and tell you that, okay, there is a further romantic movie for you to watch. So it kind of profiles you to that extent of saying that there is an algorithm at the back end which curates content primarily bases your choices. So your data is already being processed, and at some point of time that is something that we don't see a change to. The only, and I don't think the bill also seeks to do that either. However, and this is the only time where I'm happy that it doesn't go down the GDPR route, because there it says if you automatically profile, there is a bunch of other repercussions to that effect, and this probably doesn't. So at a certain level, it's way more lenient and then probably helps the industry be able to do exactly what it wants to do with regard to a viewer. On the IPR front, I honestly think that's a completely different construct, because IPR by itself is, on a jurisprudential level, will be basically a statute-created monopoly. Whereas this comes from the construct of something which is way more closer to a fundamental right of an individual. So I'm not too sure that it actually clashes, but yes, as in when we're talking about trade secrets, when we're talking about confidential information, some of those bits, if at all those are legislations which is also in the pipeline and which also comes up, yes, as in that would probably be carve-outs from the kind of corporate data, if at all. Again, this relates to data of persons, which includes corporate and legal and juristic entities. So in which case, that would probably be a carve-out from the bill itself or carve-out from those bits. So I'm guessing that's the only interface that I see.
Okay. Mr. Vajpayee, coming back to the nuances of the bill, removing an important clause of Section 8, 1J of the RTI Act and the DPDP bill can undermine transparency. Will this small amendment impact Indians' right to information and accountability? Please elaborate on that.
Yeah, no, that's a very good question, but I just wanted to supplement on what Madhav also said. There is also a process of review.
Yes.
So if there is a proceeding that is heard by a few members, the board has the power to, an application can be made, or the board itself can have the order reviewed. But coming back to your point, look, that's a controversial one. 8(1)J of RTI and this law, both these rights are pursuant to judgments of Supreme Court, but they touch some fundamental right or the other. RTI, it's all about freedom of expression and speech, and this is on right to life. So both flow from there. And ideally, there should not be any, they should actually complement each other. While I can see reason in why the other provisions are sought to get amended under the IT Act, but on this one, even if the intent is to make 8(1)J partly redundant by omitting 8(1)J, and this Section 29 does say that this will have precedence over all other regulations, and it should be read harmoniously, yet if there is a conflict, they should have precedence. But I do feel that in the scheme of exemptions that is contained in Section 18, much of the fact that 81J will get deleted will be dealt with because there is a scheme of exemptions in Section 18. So ideally, yes, they should complement and they shouldn't, they shouldn't clash, or they should be harmoniously construed or constructed. And I thought 81J was quite reasonable in carving out what it did and how it did. But I still feel that there is recourse to the exemptions, and that's how I think it will run.
So how do you all view, the DPDP bill will give government the complete access to personal data of individuals, and will there be a probable misuse of it? No?
That's not what the law provides for. And some of this, I think we all understand concerns. We all understand the fact that when the draft is being analyzed, people will point to potential for mischief, for misuse. But that's also then useful in terms of, as Dev has repeatedly said, the more information we all have, the more we can, as a body, collectively with the government, work towards making sure that we have the appropriate protections as well, right? That provide for the fact that information will not be misused.
So how differently, has the penalty version is dealt with from this bill to the previous ones? The hefty penalties, aspects relating to it. So have you...
Look, penalties are fairly stringent, fairly high, and it goes up to 500 crores for each instance. In one instance, it can be 500 crores. So I think industry's made representation. There has to be a sense of proportionality. Again, in a law like this, having such huge penalties to start with doesn't make sense unless there is enough maturity and the law has run its course for some time, people have learned from it. I don't think... Look, overall, the focus should not just be only on enforcement. Like I said in the past, when you look at the functions of Data Protection Bill of India, the first function is to enforce compliances and go after non-compliances and impose penalties. That's how it's written there. I know you need to create exceptions, you need to make an example. This is an important aspect, and data privacy is important. Supreme Court has recognized it, but I think there should be a sense of proportion in all this, and these penalties should be commensurate. It actually, by the way, also talks about there are penalties, but there are recourses available. There is mediation, there is voluntary undertaking, there is a huge amount of emphasis on hearings and opportunity of being heard. And the board, in its wisdom, can say, no, this is a small matter and we don't think it's correct to impose that kind of a penalty. So I think, while the law says what it says, but when they get down to really implementing it, there will be this sense of proportion, there will be a sense of proportionality, a test of proportionality that will be applied. And it will be only by exception and in the right cases, for the right reasons, that such hefty penalties will be imposed, is what I feel.
Yeah. Respective jury, sorry to barge in and to interrupt, but then we are just left with a minute's time. So we'll be urging you to please take a quick question from the audience before we close it and before we end this segment. Yeah, we have a question here. The mic is coming to you.
Hi, my name is Meenal. I'm the lead director for Temasek, one of the funds for Temasek. I had a question specifically for you, Madhav. You said that, how this bill, as you rightly said, doesn't categorize the various types of data. Like the earlier one had critical data, sensitive personal data, and then just data. So which meant that different rigors applied to different types of data and how it was being governed. Now, currently, it appears like the same kind of rigor is going to apply to all the different types of data. Do you really see that as a positive, or do you see that as a as a problem? That's question number one. The second question that I had is that the bill seems to focus on the severity of the non-compliance. For example, it says that if the non-compliance is not significant, the board may choose to close the inquiry and will not take remedial measures in case the non-compliance is not significant, for instance. So, do you see this to be a problem, given that what is significant or not is again highly subjective and one can really apply the discretion here? So, do you see these two? I think sort of jump out to me, these two issues.
Sure.
Thank you.
So let me take the second one first. I think that, because it's a simple one, there is a review mechanism. So yeah, if they have dismissed it on the basis of saying no merit in the case, there is a recourse. There is a recourse. Review mechanism, as Mr. Bajpai pointed out, and as well as, then taking it to the next level, High Court and the Supreme Court. So it's not that somebody does not have an opportunity to take it in an escalated manner to the next forum. So that's, and of course, any order which lacks merit, obviously, we've seen jurisprudence evolve in other areas where the courts have come down heavily, and there's a course correction. On the first one, if there is no subcategorization, sensitive, non-sensitive, I'm sure, somewhere, of course, the principles have been set in that sense in the bill. How they carve out something in the rules is awaited. We don't know what the rules will look like. Hopefully they're, not a distinguishing feature, but possibly some lesser, provisions of, non-compliance and then the consequences there possibly may be called out. We have to still see, obviously, the rules, how they'll shape out. That's how I would answer on both the counts. On the first one, I agree with you. It's great, the subcategorization, because will you paint it with the same brush, right? Should not be, because if they do so, then it will obviously go through the process of challenge and constitutionality of such and all of that. So wait and watch is all that I would say.